Education for the National Association for Civilian Oversight of Law Enforcement. I'd like to welcome all of you to NACOLE's 2017 webinar series, where today we'll be discussing strategies for successful mediation programs. Before I turn things over to today's facilitator and presenters, I would like to go over a few things. During the webinar, all attendees will be in listen-only mode. As soon as we begin, however, you will have the ability to type in any questions you might have for Rochelle or Lisa Grace. When we come to the question and answer portion of the webinar, your questions will be asked and answered as they have been received. Simply go to the questions section on the control panel and type in your question. At the conclusion of today's webinar, each of you will be given the opportunity to complete a brief survey on today's event. If you could please take a few moments to complete the survey, it will help us as we move forward with enhancing and expanding our webinar series. Lastly, I want to let you know that today's webinar will correspond to 0.75 hours of credit for those of you participating in the Certified Practitioner of Oversight program. You can find the form associated with reporting your hours available for download on your control panel or at www.nacole.org. Under the Training tab, simply click on CPO programs and it will take you to the forms. With our housekeeping duties out of the way, I would like to introduce you to today's facilitator, Florence Finkel, a longtime NACOLE member and practitioner of civilian oversight of law enforcement and a member of our Training, Education, and Standards Committee. Flo?
Thank you, Cami. NACOLE's Training, Education, and Standards Committee determined that mediation is such an important topic that it's worthy of its own webinar. For starters, police and civilian mediation participants are generally more satisfied with the complaint resolution process than those involved in complaints subject to investigation. Mediating complaints can help build police community understanding in ways that investigations cannot. And mediating complaints can save both time and money. Now, there are other forms of alternative dispute resolution, but for the purposes of this webinar, mediation is a process for resolving complaints citizens file against police officers through a face-to-face meeting, during which a professional mediator serves as a neutral facilitator. It provides the parties with the opportunity to discuss the incident in a safe and confidential setting and share their individual perspectives. Complaints are considered successfully mediated when the parties agree that they've addressed or resolved the issues raised by the complaint. NACOLE is lucky to have with us today two panelists responsible for directing the mediation programs of two of the nation's most prominent citizen oversight agencies, the New York City Civilian Complaint Review Board and the District of Columbia's Office of Police Complaints. Though the goal of each agency's program is, of course, to mediate as many complaints as appropriate, each program takes a slightly different approach in its process. The CCRB's mediation program relies on the voluntary participation of civilians and officers, and the DC OPC program a bit more closely resembles a court-ordered mediation process. Our panelists will discuss how their programs work and how you might be able to leverage their successes in your jurisdictions. First, we'll hear from Lisa Grace Cohen. For 8 years, Lisa has served as Director of Mediation at the New York City Civilian Complaint Review Board. Lisa is an attorney and a certified mediator and arbitrator. Prior to joining the CCRB, Lisa was the director of the New York Peace Institute's Brooklyn Mediation Center and its training coordinator. She was also a member of the board of the New York chapter of the Association of Conflict Resolution. Before embarking on her career in mediation, Lisa practiced law as an associate at Skadden Arps and as an assistant general counsel at CBS. Our second panelist will be Rochelle Howard. Rochelle is the Deputy Director of the District of Columbia's Office of Police Complaints, and she's responsible for managing its mediation program. Rochelle is also an attorney and previously worked as the Deputy Assistant Inspector General for the Inspections and Evaluations Division at the District of Columbia Office of the Inspector General. She began her career serving for 8 years in the U.S. Army JAG Corps, where she worked as a prosecutor, defense attorney, and NATO anti-corruption advisor to the Afghan police. Rochelle served in 6 combat missions in Iraq, Afghanistan, and Africa, as well as in assignments in Korea, Fort Benning, Georgia, and Fort Meade, Maryland. At this point, we're going to start with Lisa Grace Cohen from the New York City Civilian Complaint Review Board.
Thank you, Flo. Hello, everybody. As Flo said, my name is Lisa Grace Cohen, and I'm the Director of Mediation for the Civilian Complaint Review Board. Before I begin, there's 2 things I need to say. First, the opinions expressed in this presentation are mine and are not necessarily those of the agency. And second, I would be remiss in not thanking Ms. Finkel for laying down such a solid foundation for mediation while she was the agency's executive director. Without her, I believe the mediation program would not be as successful as it is today. Now on to the presentation. Today I'll be discussing the philosophical underpinnings of starting and growing a mediation program using the CCRB as an example. Next slide. Those arrows are, oh, there they are. Yes. All righty. Technology and I are not a good mix, but mediation and I are. Let's start with CCRB at a glance. The CCRB is an independent agency that is not part of the New York Police Department and is staffed completely by civilians. The agency's mandate is to investigate, mediate, and in certain cases, administratively prosecute complaints by civilians against members of the department, which currently numbers about 37,000 officers. After a full investigation, the board makes disciplinary recommendations. However, the police commissioner has the ultimate authority regarding discipline. The agency was established in 1993 by a revision to the New York City Charter, which included a provision unique for its time, requiring that the agency have an alternative dispute resolution process by which a complainant may voluntarily choose to resolve his or her complaint. In 2016, 1,516 cases were closed as fully investigated. 250 cases were closed by the Administrative Prosecution Unit, and 435 cases were closed by the Mediation Unit. The mediation program is celebrating its 20th anniversary this year. It began, 20th anniversary. It began in 1997 with 4 mediations. 2 salient points about the program are that it is voluntary for both parties and non-disciplinary for the officer. Complainants and/or victims are permitted to participate. Mediation outcomes are either successful or unsuccessful, and as Flo said, an outcome is successful when both parties feel that they have had an opportunity to be heard. In that case, no further action will be taken and the case is closed as mediated. A mediation is unsuccessful when one of the parties feels that the mediation did not address his or her concerns and would like the case to be returned for further investigation. In that case will be closed by the investigation unit. Another possibility is that the complaint can be closed as mediation attempted, which happens when an officer has agreed to mediate, but the complainant has dropped out or cannot be located. If a complaint is closed as mediated or mediation attempted, the allegations in the complaint are removed from the officer's record, and instead, the officer's record merely states that the complaint was mediated or mediation attempted. Both of these determinations are looked upon favorably by the NYPD. As further inducement to officers to participate in a mediation, mediated and mediation attempted cases are not considered when the department makes decisions about whether an officer should be placed in a monitoring program. Given the large number of complaints received by the CCRB and the size of the mediation unit, we are 4 coordinators and me. By necessity, investigators are our front line. Investigators screen cases for eligibility, offer the mediation option to civilians, and refer cases to the mediation unit. Let's look at CCRB by the numbers. As I said, in 2016, the mediation unit closed 435 cases, 208 of which were closed as mediated, 227 of which were closed as mediation attempted. Our success rate last year was approximately 88%. 44% of civilians who were offered mediation accepted mediation. We feel that's not a good number, and we keep working on it. 88% of officers who were offered mediation also accepted mediation. That is a good number. 8 years ago, that number was 66%. The mediation process is faster than a full investigation. It takes approximately 90 days to complete a mediation case and 145 days for a full investigation. And lastly, according to our satisfaction survey, approximately 90% of officers and 90% of civilians were satisfied with the mediation session. The CCRB has jurisdiction over 4 categories of NYPD misconduct, referred to by the acronym FADO, which stands for force, abuse of authority, discourtesy, and offensive language. Examples of each of the 4 categories are reflected on the slide. Abuse of authority has consistently been the area receiving the largest number of complaints. Lest you think that all allegations are per se suitable for mediation, the CCRB does not mediate cases in which there are allegations of personal injury and or property damage, where a civilian is filing a lawsuit, or the complaint arises from an underlying arrest. We also don't mediate if the civilian is unable to coherently participate in a mediation session, or if there is a concurrent internal affairs investigation. Now, getting to considerations for starting and growing a mediation program. Okay, on this slide are considerations for starting a mediation program. Those are: who are the mediators, who are your stakeholders, police, unions, and the community. Should mediation be mandatory for the officer and or the civilian? What is in it for the civilian? What allegations can be mediated? How will I increase officer-civilian participation? And what happens if the mediation is not successful? We'll also briefly discuss the nuts and bolts issue of a mediation program. There you go. I will discuss some of these issues in more depth. Let's look at the mediators. Sorry, guys. That was a big jump. Alrighty, let's look at the mediators. Okay, where do mediators come from? Mediators come from all walks of life. At the CCRB, mediators are not required to be lawyers, but they can't be city employees. Our mediators are required to have taken a 40-hour basic mediation training and have at least 2 years of active practice. The CCRB mediator panel currently consists of about 15 mediators who receive a stipend of $100 a case. That is well below market rate. Bar associations often have dispute resolution committees you can contact. Most large cities have dispute resolution service providers from which you may get volunteer mediators and possibly for free. And law schools often have ADR clinics. Now, how to train. You want to make sure your mediators have mediation training first. You need them to be mediators first. And then give them a more specific training regarding police procedure and agency needs. For example, when our mediators were trained, they had the opportunity to participate in a 2-day civilian training at the police academy. I cannot overstate how important it is to have the police department and union buy-in, including the willingness of the department to give preferential treatment when an officer agrees to mediate. As I said earlier, for the CCRB, such treatment includes the masking of allegations on officers' histories and not including mediated or mediation attempted cases when considering whether an officer should go to monitoring. Without union endorsement, union reps will counsel their officers to decline mediation. And it's happened to me. When I started, I got lucky. The unions and the department had just settled their long-standing labor dispute and were ready to embrace mediation. Ray Kelly, the police commissioner at the time, endorsed the CCRB mediation program in a press release. A CCRB mediation case goes through a number of approval processes. So when we say, can it intervene, or is the PD involved in screening cases and or officers? In our case, the PD is involved in screening officers. The department screens officers to see whether there is some reason the officer should not participate in mediation. They are not required to tell us if they determine the officer is not appropriate. Last year, they rejected 2 officers, both of whom had retired. That's why they were rejected. The mediation unit checks every mediation offer to make sure that the civilians are told, among other things, those salient points. Remember them? That participation in the mediation is voluntary and non-disciplinary for the officers. As the slide says, we want no surprises. No surprises. Now, now that your burgeoning mediation program is established, your next goal may be to increase the number of mediations. Basically, there are 3 ways to increase the number of mediations. Increase the number of cases that are eligible for mediation, or increase the number of police officers and civilians who agree to participate. Sorry, guys. Alrighty. In increasing the number of cases that are eligible for mediation, there are 3 hot button, I call them hot button issues that often come up. That is whether to mediate allegations of use of force, racial epithets, and whether the officers who have long complaint histories should be offered mediation. Most new programs have steered clear of mediating in these situations, including the CCRB. However, as your program matures and you gain experience and knowledge about your stakeholders, your agency, like the CCRB, may determine that many of these cases can and should be mediated. One of the most consistent criticisms of mediating use of force allegations and racial epithets is that these allegations are too serious for mediation. I believe that not mediating these allegations deprives the complainants from a voluntary process that can be empowering and often provides a better result for the complainant. Eliminating cases with allegations of injury or property damage claims will remove the most serious cases and generally cases in which monetary compensation is most likely being sought. With respect to many force allegations, the civilian is often more concerned about the offensive language than with the push. And the CCRB has found that mediation is effective in changing officer behavior. Alrighty. Racial epithets should always be taken seriously. Having mediated these cases, I found that hearing directly from the complainant how much those words hurt is an extremely effective way to drive that point home. I will tell you that I removed all of these annoying ways that information can come up on the slide. Unfortunately, I did it after the slides were sent to Cami. That's a lesson learned. Thank you for staying with me. While the policy at the CCRB used to be to include officers with a long complaint history, or if the officer has recently mediated, that policy is no longer the case at this agency. If we see an officer with a long complaint history, it tells me that since nothing else has seemed to work, let's give mediation a try. As far as repeat offenders, we see very few of them, especially within a short period of time, probably because we have 37,000 officers. As I said earlier, mediation changes officers' behavior. The agency has done a study that shows that officers who participate in mediation are less likely to get another CCR complaint than officers who do not participate in mediation. Since the study is about 8 years old now, we are in the process of redoing it, and I believe we will arrive at the same result. Increasing the number of police participants vis-a-vis training. In training officers about the CCRB mediation program, I have frequently heard the concerns listed on the slide. I was surprised about how much misinformation there was about the program, especially around confidentiality. The other common area of concern was about apologies. Why should I apologize when I was just doing my job? And the answer is, you don't need to. What you do need to do is explain that to the complainant. Apologies do happen. They are essentially organic to the process, but it is certainly not required. Civilian training. In offering, actually it's investigator training, but it's increasing the number of civilian participants. In offering mediation to civilians, our investigators are trained to address complainants' underlying concerns by first asking, why are they making the complaint? And then, what would they like to see happen? So, for example, if in answer to why a complainant says, I want the officer disciplined, the investigator will ask, what does discipline look like to you? And what if the officer is not disciplined? If a complainant says, I never want to see the officer again, the investigator should stress that the mediation will take place in our offices in a safe, comfortable environment with a trained mediator. And lastly, we're going to do this, and this, and this. Yay! And lastly, some nuts and bolts issues to consider. Your paperwork. A mediation program should have a confidentiality and consent agreement, a resolution agreement, definitely a survey form, and your correspondence, your form correspondence to complainants. A computer tracking system is most helpful in analyzing the benefits of your program and identifying and rectifying problem areas, if any, and I know there won't be. If you'd like more information, please feel free to contact me at the contact information on the slide. I will be more than happy to send samples of the various forms I referenced or any other information you'd like to have. And I thank you for your attention and mostly for your patience. Much appreciated.
Okay, thank you, Lisa. And next we'll hear from Rochelle Howard, who manages the District of Columbia Office of Police Complaints Program.
Hello, everyone. Again, I'm Rochelle Howard, the Deputy Director from the Office of Police Complaints. I manage the mediation program, as Flo mentioned, and so with my presentation today, I'll go through our mediation program, how it works, and how we execute it here. A little bit about how it's different from New York and how you can consider the options that we have here in DC. So our mediation program here is actually codified in DC Code. You can see the DC Code sections there. It's sections 5, Title 5, Chapter 11, 1101 through 1115 in the DC Code. OPC is an independent agency within the District of Columbia government. We are what's called Tier 3 independent, which we are separated from the mayor by a board. And we have the 5 board members, all have to be residents of the district, and one of them is actually an MPD representative on the board as well. So we are managed by the board. We have jurisdiction over the Metropolitan Police Department, which has approximately 3,800 members currently, and the DC Housing Authority Police Department, which has approximately 20 sworn members that manage the Housing Authority. So our goal and our mission here with the Office of Police Complaints is to establish an effective, efficient, and fair system of independent review of citizen complaints. Our mission with our work that we do here is to try to better and hopefully eventually better the relationships between the district's police forces and the actual community members that they have interactions with. We feel we most directly do that with the mediation program, and we feel we most directly do that on the individual perception level within the mediation program. And you can see with Code Section 5-11023 that we encourage the mutually agreeable resolution of complaints through mediation where appropriate. And we'll talk about when we decide what's appropriate and what we have jurisdiction over as far as allegations. Again, our mediation part of our program here at the Office of Police Complaints is statutory in the DC Code. Generally, the executive director of the Office of Police Complaints has the authority to investigate, conciliate, mediate, or dismiss, and that's written in code as well. The executive director shall establish a pool of qualified mediators. This is all language from the code, shall be assigned to carry out the mediation and the complaint determination function. So we actually, again, this is just showing you the statutory authority we have for the mediation program and its creation existence. Now, a complaint can be dismissed out of mediation if the complainant and also the officer do not participate in good faith. And so we define good faith as making yourself available to mediation, being honest in the mediation as best as you can be, speaking your mind in the mediation, but most importantly, and also including listening to the other person's perspective. We use the transformative facilitated model of mediation. We talk to our mediators about this. We talk to the mediators about how they can incorporate their expertise into this transformative facilitated model. And that's where the mediator is there to facilitate a conversation to transform the perceptions of the complainant and then the officer. So we consider mediation for any and all allegations. We have a screening process that I'll talk about here in a moment, but we screen all cases and all complaints that come through the door for mediation. There is no type of allegation that's restricted from mediation. We do, however, if there are potential crimes, for example, we've seen cases where there is potentially or maybe perceived, or we have to figure out if there's a warrant out for the arrest of the complainant, we don't want to bring them in for mediation. But if there are crimes that could be pending against the complainant or the officer, we are mandated to send those over to the U.S. Attorney's Office to see if they want to accept or decline prosecution. So if we do think there may be criminal matters involved, we send it over to the U.S. Attorney's Office here in the district and make sure that they have a ruling and a decision on whether they want to prosecute those cases or not. These are the 6 types of allegations that we have administrative jurisdiction over to investigate: harassment, force, language and conduct, discrimination, retaliation, and failure to provide identification. And I'll just give you a little information more about what those are defined as. Harassment can be a bad ticket, a contact entry, intimidation, mishandling of property, etc. Force can be canine force, chokehold use, a foot on the back by the officer to the complainant, forcible handcuffing. Language and conduct can also be demeanor or tone, gesture or action, profanity, racial or ethnic slurs. Discrimination could be age, color, disability, national origin, personal appearance, and others. Retaliation could be past experience with the OPC related incidents where the complainant feels like they're being retaliated by the officer for filing complaints previously. And then in DC, if a complainant or a citizen that they're involved with asks for their name and badge number, they're required to give it to them. So it could be an allegation of misconduct if they fail to provide the identification when asked by the complainant. Our complainants actually have to have personal knowledge of the incident. They can, if they have personal knowledge of the incident, file on behalf of another complainant or the victim in an incident, but they have to have the personal knowledge to support those allegations. So let's talk about our complaint screening process. As I mentioned, the investigators, when they get complaints, they screen all cases for mediation to determine whether or not it can go to mediation. That's one of the first things that they do. And involved in this, we've been working with the investigators to make sure that the complainants are fully informed about their options in mediation and know that that's an option of disposal of the case. As I mentioned, the executive director can conciliate, mediate, dismiss, or investigate. And so our investigators discuss those options of the complaint with the complainant, and in that conversation ask them how they feel. If it were to be referred to mediation, would they be interested in mediation? And then also explain to them what the requirements would be if they fail to participate in mediation once it's referred. The investigators have this conversation with the complainant. When the complainant comes in to take their formal statement, we do record all of our statements. Sometimes this conversation happens in the recording, sometimes it does not. But we have the complainants acknowledge a sheet where they acknowledge that the case can be investigated, it can be dismissed, it can be referred to the U.S. State Attorney's Office, it can be mediated or conciliated, and also the requirements of their participations in any of those avenues of dismissal or disposal. And like I mentioned, the investigators discuss with the complainant in mediation, as kind of Lisa talked about, we want to make sure we understand their goals with their complaint. And if we're considering mediation, we also want to understand their goals with mediation, but after being informed about the process and how it works. It's really helpful to tie the screening process with the investigators, because they're the ones that have the initial contact with the complainant, to our mediation referral process. And so we have a form in our, if an investigator refers it to mediation, there's a form that they fill out that tells them, that gives them the opportunity to put information in there that will go to the mediator. For example, if a complainant wants to mediate the case because they want to tell the officer how they felt about the interaction, but they have concerns about being bullied by the officer, of course we explain to them that that's what the mediators are there for, to protect, and it will not be that type of forum. But we do, in the documentation and the referral to the mediator, we do send those concerns over to the mediator so that they understand where the complainant is coming from, even though they've agreed to mediation. We also check the availability of the of the complainants to make sure that they will be available in the next 45 days. So if there's any scheduling issues, for example, if the complainant can't take off work, we'll pass that information to the mediator to make sure, if they can, that they schedule an evening mediation. If the complainant has the goal of, a goal specific to the incident, they don't understand a specific part of what happened in the interaction with the police officer, we will also put that information into the referral process to make sure that that gets to the mediator to hopefully help the facilitated part of the conversation within mediation. This is the screening questions that the investigators go through when they look at a case and work with their investigative manager to decide if a case is appropriate for mediation. So I'll just briefly go through these to let you know kind of the things that may be considered in this screening process. Are the officers eligible for mediation? We do not allow officers to mediate the same complaint within a 12-month period. So if an officer comes up and we think it's a good case for mediation, but he mediated the same allegation within the last 12 months, we will not again send that to mediation. And you may be asking why, and the why is because if the officer went through mediation for language and conduct 3 months ago or 6 months ago or 9 months ago and hasn't realized, has not potentially transformed his thought processes about that, we will not allow him to go through that same process for that allegation. Is the subject officer correctly identified? We always want to make sure we have the right person in the mediation, and so we do the investigators do multiple different investigative techniques tools to make sure that we have the right person in there. We also make sure we know from the complainant who they wish to mediate with. We try to ask the complainant if there's only one of the officers that was involved that they want to mediate with. Sometimes they say, no, I had this concern with these two officers, but we try to keep it to one officer for the facilitation of the conversation, but we have mediated with two officers if that's really what the complainant wishes to gain out of it. Other reasons not to send a case to mediation. Some of those considerations may be that the complainant is completely fearful of the officer. And if that's something that we don't think can be alleviated with the mediator, we won't force the complainant to go through the mediation process. Of course, the complainant's demeanor and whether or not it would be a good situation for mediation, we take that into consideration as well. Do any of the video recordings contradict the basis for the complainant's allegation? We don't feel it's necessary to send a case to mediation if the complainant's allegations are disputed by some of the evidence. Our goal with mediation is to clear up any misunderstandings or any confusion from the incident. If the complainant's allegations are not seemingly confusing or misunderstanding, we don't feel like it's a good case for mediation. And again, in 6, as I just mentioned, is there a misunderstanding regarding the incident that can be discussed in mediation? We feel that's the best, most right scenario to send to mediation so that the parties can talk about what the confusion was. Of course, the complainant or the officer may have a perception about why something happened, and if that perception can be cleared up, that's a good case for mediation to us. What are the likely benefits of the mediation? That ties into 5 and 6 to make sure that we're serving the goals of facilitating transformation of perceptions and future interactions between the complainant and the police officer. We also ask would the benefits of mediation outweigh the result of finding misconduct. Potentially there are some types of allegations or some types of incidents that it may be more beneficial to pursue the investigation route and determine whether there's misconduct instead of sending it to mediation for a misunderstanding. And of course, as I mentioned earlier, if there are ongoing criminal litigation matters, we will also consider whether that would affect the availability of mediation. So I talked to you before and showed you the code where the officers and our officers and our complainants are obligated to participate in mediation. And so we don't want to force anyone here, make them come for mediation because they're obligated and there's a pending criminal or civilian or civil litigation or action going on. So the referral process. So after the investigators screen and work with their investigative managers on whether cases are good for mediation, it comes over to our program coordinator, Chris Weber, who manages the day-to-day operations of the mediation program. Chris will send a notification letter to the complainant and the officer letting them know that their case has been referred to mediation. The officer will have previously been notified that they are involved in a complaint that we've received. Usually we do not all the time, but usually we do not interview the officers before the mediation. So the next time that they hear from us, if a case is referred to mediation, is when they get the notification letter. We also send our mediation brochure to them, and the letter explains that before kind of the mechanics of the mediation. It explains to the officer that the mediation session is confidential by law, and I'll talk about that, that they're going to be contacted through the notification system for an appearance date, and that how the end of the mediation will happen. So if that is resolved, we explain resolution to them, the case will be closed expeditiously. Right now we're actually closing them within 24 hours after the mediation session is over. So we send notifications to the complainant to let them know it's been referred to mediation and X mediator will be contacting you. We send the notification letter to the officer explaining the things that I just mentioned. Then we send the referral packet to the mediator, letting them know information about the case. We give them a copy of the complaint and any relevant documents. We also give them a cover sheet with contact information for the complainant and identification information for the officer. And then we also give them a summary of the allegation, and that other sheet that I talked about that passes on any information from the investigator to the mediator about concerns or administrative information that the mediator should have from what the investigator learned in talking to the complainant. So in the Metropolitan Police Department uses what's called a court-assisted notification system. It's called CANS. The way that the officer's appearance is mandated is through that CANS process. So once the mediator determines a date and time for the mediation, they send an electronic CANS to the CANS office, letting them know that that officer has to appear at this date and time at our office for the mediation session. The officer is given, we have to send those CANs over 7 days prior to the mediation. There's a 7 days advance notice that is required for the CANs appearance, and then that's what the officer has to respond to. It's the same equivalent as a court order. When the officers are ordered to court or need to appear in court, it's the same process that's used to have the officers in DC appear for court. So our mediation process and outcomes. Before the mediation can begin, this is kind of the things that we train the mediators on to make sure that they're aware of this, and this is also a lot of the conversations that I have with the union and police officers about the mechanics of the mediation. Before the mediation can begin, all the parties have to, by law, sign a confidentiality agreement, and that comes from the Uniform Mediation Act, which is a federal document, and it was adopted by DC. It's in DC Code Title 16, Chapter 42, where they've adopted the Uniform Mediation Act, which says any mediations in the district must be kept confidential. All parties have to sign, and a mediator is a party to the mediation here in the district. All parties have to sign the confidentiality agreement, and then we have a few other notes here that we put in that confidentiality agreement to protect it, which are in line with the Uniform Mediation Act. The mediator does not provide legal advice. Nothing from the conversation can be disclosed. There's no recordings. None of the statements are admissible in court, and the mediation will and should stop the mediation anytime if she feels like the goals of the mediation are not being served. And so I explain to the union all the time, I explain to officers all the time to make sure they're educated in how the process can be to their benefit. The statements in the mediation are completely confidential because we require everyone to sign that confidentiality agreement, and because of the laws in the DC Code under the Uniform Mediation Act, and then our code about mediation says that nothing can be disclosed. So that allows the office to protect it against subpoenas, FOIAs, and in future proceedings. There are precedents of court cases in the district where if someone was in a mediation and they try to use statements in a future civil or court proceeding, they will be sanctioned for that attempted use of disclosing the mediation statements. So it's completely confidential, and it's protected by law. And the DC Code, the second bullet, DC Code section 164201 through 164213 is where DC adopted the Uniform Mediation Act. So to go through the mediation, and as I talked to you about, we have our mediators use the transformative facilitator model, which is facilitating a mediation to transform the perceptions, usually clearing up a misunderstanding, allowing the parties to explain their sides, allowing the parties to talk through any misunderstanding or confusion about what happened in the incident that originated in the complaint. If the parties feel like they've been heard and nothing else needs to be raised out of the complaint, we ask them to sign a resolution agreement. And the way we define resolution and the way that we explain it to the mediators, the officers, and the complainants is if you have been heard and you felt that that conversation was a good conversation, was beneficial, that you might not agree to everything, the misunderstanding may still not be cleared up, but that you had the opportunity to be heard and to listen to the other side's party, that's where we feel a resolution has happened. The only two pieces in our resolution agreement that they have to physically or technically agree to is to continue to adhere to the mediation confidentiality agreement, and that they also agree that OPC will take no further action regarding the complaint. When they sign the resolution agreement, that's what they're agreeing to, that it will remain confidential and that OPC will take no further action against the complaint. But we do talk to the mediators about the goals of resolution, how we actually define resolution, so that they can then sign the resolution agreement. It's a little different.
Rochelle, sorry, yeah. I just want to point out it's about 1:45, and we do want to save some time for questions.
Okay.
See, yeah, 5 more minutes possibly.
Yep, I have 2 more slides.
Excellent.
3 more slides. If the parties do not agree to a resolution agreement, the case is returned to the investigation unit to pick up where they left off in the investigation. We bifurcate the mediation from the investigation because it kind of is an option in the investigation. So if the mediation is resolved, We close the case out. We say that the allegations are closed based upon a mediation agreement. If it's not resolved, it goes back to the investigator. All the investigator knows is that it did not resolve in mediation, and they pick up where they left off in the investigation. It runs its course based on the facts. Complainant officer participation. If the officer fails to appear, this is in our code, he can be disciplined by the chiefs of police. We have a whole process where we send discipline memos over to the chief of police and let him know that an officer failed to appear after being notified through the court-assisted notification system. If a complainant has agreed to a mediation, sets the date and time with the mediator, and then doesn't show up, if there's not a justifiable reason, we will usually dismiss the case because that's not participating in good faith. Another thing that apparently is different for us, if the officer is excused or the complainant asked to the officer can be excused from the appearance, or if the complainant asked to reschedule for a justified reason, we will try to work that out. The mediator will work that out with the parties and attempt to reschedule. If a complainant's not reachable after we refer it to mediation, we can dismiss the case as well. So our mediators, last year we went through, we eliminated our single contractor mediator system, where we went out into the district market and we did market research to see what the DC mediation industry could offer. And we were allowed to expand from that research. We were able to expand our mediation pool. So now we have mediators from the Federal Neutral Sharing Program, which is where mediators are either paid employees or volunteers in the federal government agencies to mediate between agencies or with agencies for employment disputes. That we also have independent contractors who are private experts in the mediation world in the district. We also have nonprofit vendors that provide a mediation pool through the avenues that they gain mediators that way. They're all on contracts and they are all paid for their mediations. We pay $400 for mediation, for each mediation. We do have surveys. These are some of the questions that we have on our surveys. We also test the satisfaction by the officers and the complainants for their mediation program. We also are attempting to figure out if the attitudes have shifted during the mediation. We're actually going to update our mediation surveys on April 1st and see how it works, see what turns out in the second half of the fiscal year. We want to know, going into a mediation, coming out of mediation, the officers have a perceptions of complainants and complainants of officers, if those perceptions change after the mediation session. And one last slide. So these are our mediation statistics. In FY16, we had 86 cases referred to mediation, and so far this year, we've already had 49 referred to mediation. We have held 32. We keep the resolution rate internally, but we don't use the resolution rate as a determiner of satisfaction in the survey, because unresolved cases do go back to investigation. But of FY16, the amount of cases that resolved the case at OPC through mediation was 13% of all complaints received. And so the middle chart I actually got from NACOLE, a document that was put out called Civilian Oversight of Law Enforcement in coordination with the OJP Diagnostics Center. It's called Assessing the Evidence, and comparing the sworn forces to mediations completed in FY15, 11.1 mediations were completed per 1,000 officers, and so far this year we have 8.4. Another thing that we track, and I would encourage everyone to do this if you're considering starting a mediation program or adapting your mediation program, is the average days between intake and referral, and mediation. It's kind of a philosophy here that the sooner we can get the mediations to the table, the more satisfying it may be in the session. And so FY16, the average days between when we referred a case and it actually went to mediation was 41.5, and so far this year we've been able to drop it down to 21. So it's only been 21 days before referred to actually completing the mediation as an average. So the staff that's involved is myself, the Deputy Director, and Chris, the Program Coordinator, as I mentioned, and those are our responsibilities. And this is our contact information if you have any questions about our office or the mediation program.
Thank you, Rochelle. And now we're entering into the Q&A part of the webinar. And as Cami indicated at the beginning, you're free to input your questions on the menu on the webinar control panel. We already have a few questions in the queue. First question is, first I'll ask Rochelle, how in one of your slides you mentioned that the budget for your mediation program is a total of $44,000. The question is, how is your program funded? Is it out of the general budget for the agency, for example? And the second part of this question is there a fee for participation?
Great question. So whoever, thank you for asking. So $44,000 for the mediation program last year came out of our local operating budget. The Office of Police Complaints is only funded by local funds. We don't have any grants. We don't have any funding. It comes from the District of Columbia as local funds. And so $44,000 of that went to the mediation program out of our operating budget. The agency's total budget is a little over $2 million. Most of that is salaries. And so our biggest programmatic spending was and is the mediation program each year. But through the market research that we did last year and expanding the pool to diversified pool of mediators, we were able to reduce the cost of mediation by 50%. So now we pay 50% of what we used to pay for a mediation, as I mentioned. And so there is no fee for participating in our mediations.
And Rochelle, your contract with the providers, is it pursuant to a price per mediation, or is it just a yearly fee to each contractor?
So the statute actually says that we can only pay a flat rate fee per mediation. And so that's where we pay the $400 per mediation. We only pay for mediations held because we leave the scheduling up to the mediator to work it out with the complainant, and the mediator then has to, because they're the one holding the mediation, send the cans. We leave the scheduling up to the mediator. So there are times where a mediation doesn't happen, but per the code we pay a flat rate fee per mediation held.
And Lisa, how is the CCRB mediation program funded, and do you have a figure as to what the actual funding is? You did mention that you pay each mediator below market rate of $100 per mediation. And I know that there's no separate fee for participation. Correct.
The mediation program is funded, well, let's start with the agency. The agency is funded by the city. We are going through budget hearings now. I think our current budget is something like $14 million, and the mediation unit does not have a separate budget.
Okay. Question, I think more than one attendee has asked this, can we get a copy of the PowerPoint presentation after the webinar? And I'm going to fall back on Cami. I know that after a certain number of days, NACOLE will post the webinar on its website. Can you let us know what the time frame for that is?
Yes, the PowerPoint, the recording of the PowerPoint presentations will be online in about 30 days. And if there are copies available following the presentation, for instance, PDF versions of the PowerPoint, then we can send those to those who signed on to the webinar.
Great. Okay, I'll ask this first of Lisa and then of Rochelle. The question is, could you give us some examples of successful resolutions and unsuccessful solutions with some details about how things played out during mediation? And let me just add that I know from looking at the CCRB website recently that you actually have summaries of certain cases that went to mediation. But Lisa, can you give a quick summary of one or two cases that were successful and unsuccessful?
Sure. Keeping in mind that mediations are confidential, we had a mediation. The facts were that two officers went up a fifth floor walk up, and the call was neighbor dispute. And the two neighbors were going at it, and one neighbor filed a complaint alleging use of force and discourteous language. They come into the mediation, and this is a perfect situation for mediation. Neighbor disputes and domestic violence disputes are one of the most scariest calls an officer can make. The next being, well, I think the scariest is walking up to a car, but bad things happen there. So the officers know what they need to do is de-escalate the situation. The officer explained that to the complainant, and explained to the complainant that he focused on her because he thought she was the most reasonable of the two, not that she was the worst. And his reasons for doing so was her safety. She liked that. That was a good thing, and it took a little discussion, but the conversation went from discourtesy to doing your job and keeping people safe. They ended with a handshake, and I dare say it, an apology, and that was a good mediation. A bad mediation, well, unlike DC, we can't discipline officers who don't participate in good faith. I had one officer sit throughout the mediation with his arms folded across his chest and not say anything. It was a very short mediation. In that case, the complaint went back to investigation, and if there's justice in the world, this officer got a substantiated complaint. I don't know. We don't check back. So they run the gamut. I had a mediation where an officer volunteered to coach the complainant's son's basketball game. They walk out, maybe not best friends, but certainly with an understanding of why the officer did what they did and an understanding of what happened vis-a-vis the complainant as well.
All right, next question is for Rochelle. Rochelle, do you know what contributed to the reduction in the amount of time that it takes your agency from referral to the completion of the mediation?
I think the referral process from investigations to the mediator and then also working with the mediators, we have made sure that the investigators have the opportunity in the beginning to screen the cases and send it directly to mediation as soon as they see fit, and what's required in that they work with their investigations manager. I think screening them all for mediation at the beginning saves time, because then we can send it over to mediation to see if that works out. But then also, more importantly, working with the mediators. We've been working with the mediators to understand our goals, and I personally believe that the sooner we get it to the table, the sooner and more satisfied the complainant feels like their complaint has been given attention to. So we've been working really hard with the mediators for them to understand having multiple mediators too. Letting the mediators understand how expeditious scheduling works well. But then having multiple mediators, as I mentioned, we eliminated our single contractor mediation contractor. We have multiple mediators now. So if a mediator is not available, I can send it to one that is available. If a mediator has 4 or 5 cases already scheduled, I'm going to send it to another one so they're not scheduling all these other ones. When we only had one vendor as a contractor with one program coordinator, I think that took more time to get scheduled depending on the mediators that were available. So I think diversifying the pool of mediators and having as many mediators available as you can helps with the timelines.
Thank you. Lisa, you've talked about unions as a stakeholder in the process and how important it is to get their buy-in. A question from a listener. Can you talk about the influence of the various bargaining units on mediation? And I know in New York, and from speaking to you, that there was one of the bargaining units that has been opposed to it. So can you talk about the influence of the various bargaining units? And if you know, do any of the collective bargaining contracts mention citizen police complaint mediation?
I don't know about the bargaining contracts. That would be an awesome thing, but I don't know. Union influence is huge. Union reps come with the officer to CCRB when officers give statements. They'll come down with an officer for mediation, or they'll tell the officer, we don't support mediation and do not mediate. Luckily, it's only one union. We've gotten all the rest on board, and that union is the detectives. It seems the detectives don't like to get yelled at, which I find ironic, but it won't go into. Having said that, and I've met with the head of the union, he's just against mediation. Like I said, having said that, by now 50% or over 50% of detectives do participate in mediation. So
do the officers always come with union reps on the date of the mediation, and are the union reps ever allowed in the mediation room?
That's not a usual situation. What happens is the union rep comes down because there's so many officers. The union rep comes down when an officer is giving is being interviewed, and then will proceed to tell somebody who's there for a mediation not to mediate, and that's happened. Luckily, it's very rare, and I think that person is no longer a rep. So it definitely does affect the process, and absolutely not. The union rep does not come into the mediation. No third parties come into the mediation. No witnesses, no lawyers. It's just between the complainant and or the victim and the officers.
Now, Rochelle, your process, the officers don't have a choice about whether mediation is scheduled or not. Does the union play any role in DC in your process?
We also do not allow union reps into the mediation. The mediators have the philosophy of an emotional support person, so we're working on, if the complainant wants an emotional support person, offering that also to the officer, because that's what the mediators feel is best in our industry down here. But we do not allow union reps in the mediations, and I actually met with the union this morning to talk to them about how we can move forward so that they can educate their officers about mediation. There's a lot of officers that either have never been through mediation before or don't feel comfortable coming to our office for anything, so they're not sure what this mediation thing is. When I talk to the officers here in the office when they come for a mediation, and I explain to them the confidentiality, how resolution works, the benefits, the model that we use, and how we manage the mediators and contract out for that, they have always participated in the mediation thereafter. So the most common scenario right now is that they will show up with a union rep. The union rep will be excused from the room so that I can talk to the officer and give them the information that they didn't get from the union or the union rep about the confidentiality, about the benefits, and in every situation, the officer has then participated in the mediation in good faith. And so we're still working on the union to make sure we're all giving out the same information, because it is required, it is mandated. We don't want anyone to be disciplined for not participating in good faith when they were misadvised by another person outside of our office and giving them the information. So we are working with the union on that. But we only have one, we only have one collective bargaining unit here, and it's between the Metropolitan Police Department and the union. Office of Police Complaints is not part of that contract, so we're not part of the collective bargaining.
Right.
So
I'll start with Rochelle, and this is a final question, and I actually have a question. Is the outcome simply greater understanding of the situation, or do the parties ever agree to take specific actions? If so, if one of the parties agrees to take a specific action, is there any follow-up? So it's a three-part question.
So our resolution agreement just has those 2 points that I mentioned, that everyone agrees to keep the mediation confidential and that there will be no further action by OPC. So because we have them agree that there will be no further action by OPC, we can't then enforce an agreement. So but there's nothing in the facilitated transformative model with the mediators running the mediation that prevents the parties, the officer and the complainant, from agreeing to terms that they individually, outside of their formal capacity on the police officer side, agree to follow through with. And in the past, there have been agreements. It's just we don't get into the business of enforcing them, but there's nothing to say that the two parties in that room agree to. I do know there was an agreement in the past where a child was involved in the incident, and the complainant and the officer agreed that the complainant would bring the child down to the police station to interact with police officers, to not be fearful of police officers anymore. If they agree to that in the mediation, that's on their own accord. but we don't discourage it. It's just not part of our resolution agreement terms.
Lisa?
Same thing, exactly the same thing.
Okay.
Our resolution agreement restates the confidentiality agreement and states that the mediation was successful and no further action will be taken.
Okay. I have two other questions. With the advent of video, I was very interested in Rochelle talking about the OPC make a decision based upon video evidence that there's no misunderstanding and they will not, they might make a decision not to refer that case to mediation. Can you speak about what the CCRB's view is, Lisa? Mediation
is offered regardless of what the investigator thinks the disposition might be. If there's video evidence showing this officer can be exonerated, that has to be fully investigated, go to the board. If a complainant wants mediation, the investigator is not supposed to consider the disposition. The case comes to mediation and the investigator mediates. Mediation is not about who's right and who's wrong. It's about understanding what happened. And notwithstanding that the officer could have been exonerated, the complainant still doesn't know what happened and made a complaint. And complainants who participate in mediation are complainants who are going to cooperate and go back and say, gee, such and such officer, that wasn't so bad. So it's not about evidence.
All right. I was going to ask a final question, but I think that the listeners can follow up with our panelists. My question was really, I think the agencies have slightly different policies about what civilians can participate in the mediation, like someone who's a minor, for example, who is involved in the incident. If we have the time, actually, we're going to take 1 minute to do this. Rochelle, can you speak to that point for first, OPC, and then we'll have Lisa answer that question?
So we allow the complainant and the officer and the mediator to participate in the mediation. Our mediators have asked, like I mentioned before, about the emotional support person. And so if that's something that a party wants, we're working on offering that to the police officer so that they both can have equal participation from support people in the mediation. But those are the only parties that we allow in mediation.
Right. I wasn't really asking about emotional support. I was asking about someone who is actually involved in the incident. More than one person, for example. In New York, you don't have to have personal knowledge of the incident to make the complaint. Lisa, what's the process in New York?
A complainant, let's say an officer is hassling a young man and a complainant walks by and is incensed by the event. The complainant can certainly call the CCRB and make a complaint, and that can be a mediation. If the complainant knows the victim, we'll take that information down and we'll contact the victim to see if he or she wants to participate. Obviously, if somebody wants to participate and somebody doesn't want to participate, then we don't have a mediation and it goes to investigation. We'll do our best to try to identify the victim, check arrests and the like, but that's participation.
Could you literally have both the complainant and the victim?
Yeah.
And one final question from one of our listeners. I know, Rochelle, you talked about some information the agency provides to the mediators. Our question is specifically, does the mediator get beyond what you talked about, do you provide any other substantive information to the mediator prior to the mediation? And in this questionnaire, it was specifically video footage.
We do not. We don't provide any of the evidence other than the complaint form to the mediator. So we would consider body-worn camera footage evidence.
Lisa, what does the CCRB do?
Same thing. The mediator gets access to the case file, no video, no evidence, basically looks at the officer's history, complainant's history, and the complaint.
All right.
prior to
Well,
the mediation.
I think that wraps things up. We went a little bit over, but I want to thank our presenters and NACOLE for a very successful webinar. And again, if our attendees have any additional questions and or want to obtain examples of the specific paperwork that's used by OPC or CCRB, I encourage you to contact either Rochelle or Lisa directly.
Thank you, Flo. Thank you, Cami, and thank you all for listening.
Thank you, everyone, and thank you for those who've attended today. Just as a quick reminder, our webinar series still has several topics to address this year. We are excited to announce that this May we will hold our next webinar, which will explore how we can assess the credibility of witnesses. Please watch your inboxes for additional information about upcoming webinars, including dates and when registration will be open. We once again thank you for joining us as we continue to bring together individuals and agencies working to establish or improve civilian oversight of law enforcement. Thank you, and we'll see you next time.